put on imports. Capitation taxes, which are taxes that the federal government, that I don't believe they've ever imposed one, but they're authorized to, and that is a tax just saying everyone in the country has to pay it. But the thing about a capitation tax is every person has to pay it, and within each state, every person has to pay exactly the same amount. So that's not the case here, because again, it would be an issue of maybe people in New York pay $600, while in Virginia we pay $500, because everyone knows that taxes are ridiculously high in New York, but for whatever reason, it must be uniform, so it's not that. And the fourth is the income tax. Now, we know that these limits are real, because the reason we have a 16th Amendment to get an income tax is in 1895, Pollock versus Farmers Loan and Trust, the Supreme Court had imposed Congress had imposed an income tax. And the Supreme Court struck it down, saying there's only 3 types of taxes allowed in the Constitution. This is none of those 3. Therefore, it's unconstitutional. And for that reason, we passed a constitutional amendment, the 16th Amendment, to authorize an income tax. So now there are 4 types, but only those 4. This is none of those 4. So even if it were a tax, it would still be unconstitutional. The idea that this is some sort of free-flowing general welfare power, the Supreme Court held in U.S. v. Butler 1936 and Helvering v. Davis 1937, that the General Welfare Clause is not a source of any government power whatsoever. It is a limitation on government power. It is to say, if you have a tax, the tax must be for the general welfare in addition to being one of these 4 approved sorts. Or if you're spending money, it must be for the general welfare, meaning the national well-being, in contradistinction to the well-being of just one group or just one state. And finally, the necessary and proper clause, the Supreme Court's made clear as recently as this past term in U.S. v. Comstock, that the necessary and proper clause must be predicated upon an enumerated power. That all necessary and proper gives is whatever implied powers are necessary to carry into effect one of Congress's enumerated powers. But if there's no enumerated power, then nothing can be necessary and proper to achieve it. So for all of those reasons, not having any basis upon which to base the mandate's unconstitutional, I believe. And I think it'll be held that, I think the odds are more than 50-50 it'll be held that, but I think frankly it's going to be a 5-4 vote. I think this is going to be Lopez and Morrison all over again, though I think this case, one way or the other, will be one of the most significant in the history of the United States. If the mandate is struck down, then in doing so, it will be the biggest thing that the Supreme Court has ever struck down. And it's going to really reinforce the idea that the federal government is a government of political power in a way that has not happened in decades. And I believe we will have the top cases ever. If this case goes the other way, if the mandate is upheld, then I think this case ties Marbury v. Madison as the most significant Supreme Court case of all time, because this will be the case that stands for the proposition that there are absolutely no limits whatsoever on the power of the federal government, outside the limited enumerated rights that you can point to in places such as the Bill of Rights. If you can't hang your hat on one of those specific rights that are burdened by a government action, that the government just has authority to do anything that it says is related to any of its members. So while we could go on for another hour, I think that's sufficient. Thank you so much for having me, and I'm happy to answer any questions. Questions? Yes, sir.
Thank you very much.
Thank you for having me.
I've kind of been a fan of authority, but I've read Professor Overton's comments on it. I think no 2 out of 3 out of 3 isn't familiar with his work, but he's one of the leading constitutional scholars in America. Sure. He thinks this also doesn't stand a chance. He thinks there's no way this is even making the Supreme Court. The Supreme Court's going to say, we don't want to get involved in this, this isn't a legal jurisdiction. And I think one of his main points, the one I agree with, is that it's kind of erroneous to say that there's a big difference between car insurance, health insurance, and everything else. Because that's why everyone does need health care of some description. The only question is how that should be provided. And Congress says this is the way it should be provided. They have established powers of tax, as a punitive tax, as really good about that. President Sherman says that's enough. The fact that we have that, the need of the whole population for health care at some point in their life is enough for Congress to take this action. Why do you think he's wrong?
I'm glad that you're here. I was hoping we'd get a question that would kind of mix it up, and thank you for being with that. The first thing that Dean Chemerinsky wrote on this It was in Politico. It was a rebuttal to me by name. If you go to Chemerinsky's piece in Politico, I think third week of October, he will say Klukowski's argument is flawed for the following reasons, and then he delves into it. He published it 2 days after I published my piece in Politico, the second piece out there to my knowledge anywhere, describing why the mandate was unconstitutional. So I've never met Erwin Chemerinsky, but evidently I of course know who he is, and he evidently found out who I was and decided to engage me in public debate. Because that's the same argument that the Supreme Court rejected in Lopez and Morrison. It's exactly the same argument. Now, setting aside health care, is there a way to make a plausible argument for why this is constitutional? Absolutely there is. In this case, could go that way. I hope it doesn't. I don't want it to. But that's what I was closing with. This case could go that way. There is a way to reason this as to how that would be the case. But it would go back to what Chief Justice Rehnquist said at the end of Lopez, and that was reiterated in Morrison. And that was, if the federal government can do this, they can regulate any aspect of your life. There is no limiting principle to the quanta of federal power that would be conferred by that concept. And I have no doubt that Erwin Chemerinsky thinks that the federal government has absolute power to do anything it wants to any of us. Which is why plenty on the left would love to see him on the U.S. Supreme Court. So that argument is out there. It's a plausible argument. The question is, where can you draw a line to the limit of power? And his position is a position that has no limits to it. So we can have it. But if we have that, we're going to have a national government that has absolute power over all of our lives. They can regulate whatever they want. Thank you for asking. Very good question. Yes, sir.
Hi, my name is Kenny Alter, and again, thank you for coming today.
Thank you for having me.
I'm not sure that it's true that there's not going to be a limiting principle. I mean, I can see ways of distinguishing the individual mandate provision from cases like Morrison and Lopez. Both of those cases dealt with criminal statutes that were justified on national productivity reasoning, and here we're dealing with something that is inherently economic. It's healthcare in the United States, and so you could say perhaps the distinction for constitutional purposes is not between activities and inactivities, but rather between things with economic effects and non-economic things with economic effects. I think that could be a distinction derived in Lopez and Morrison that we see there, right, that allows for us to save this legislation without eroding the line that the court drew in those two cases.
I think you're wrong for the following reason. I appreciate what you're saying. In Lopez, you did have an action. Someone had purchased a firearm. What the court was saying in Lopez was the action of continuing to possess and hold it and move it around was no longer commercial. Still activity, but because the activity was not economic. Now, you need to buy ammunition for a gun. To the extent that you have a gun in your car, you are incrementally increasing the weight of the car. That is going to impact fuel consumption. You're going to have to buy more gas as a result. So there are indirect economic consequences to the possession of a firearm. So too with VAWA in Morrison. The Congress stacked the VAWA statute with findings for interstate commerce. And sure, you can make an argument that if someone beats a woman within an inch of her life and breaks her arms, you have now impacted her economic productivity. That too will have an impact on interstate commerce. But the act of the crime itself, and the court drew no distinction as to whether it was criminal, civil, that was irrelevant. It was that the action that was involved was not an economic action. That was the distinction that Morrison turned on. In the case of this, there's not even an action. Not only is it not a non-economic action, it's just not an action at all. You do nothing to trigger the law. The law regulates you as a human being. Can you make an argument as to why the government should be able to do that? Absolutely. But there is no Supreme Court precedent on point currently supporting that, which is why it would be brand new law. It would be an expansion of federal power.
All right. I don't want to get yelled at like we did last time by the incoming professor, so we're going to wrap up. Thank you for coming. I don't see you.